for today. I don't think we have time for questions because I talk too much, but feel free to reach out and ask me any questions you have at TX Plant Guy on social media, and I'll be around here if anybody has any questions. But thank you so much again for having me, and I hope you all have a great conference. Thank you.
Thank you, Daniel. That was a great presentation. I really enjoyed that. Dr. Todd Votteler is editor-in-chief of the Texas Water Journal. He is the president of Collaborative Water Resolution, LLC, which is devoted to resolving water conflicts through mediation and strategic issue and analysis. He is also partner with Four Worlds Consulting, LLC, a Corvallis, Oregon-based collaborative partnership dedicated to positive transformation in our relationship with the world's water. Dr. Votteler was appointed as the Federal Special Master for Endangered Species Litigation over the Edwards Aquifer, Sierra Club versus San Antonio. His previous experience also includes research scientist for Pacific Northwest National Laboratory in Washington, D.C. He was executive director of the Guadalupe Blanco River Trust, a 501c3, and chairman of the Texas Land Trust Council. And if you guys will please help me welcome our next speaker, Dr. Votteler.
Okay. Everybody hear me? So let me just start off by saying thank you to Russell Grubbs and CE who were able to get me up here to the Panhandle today, which I've really been looking forward to be up here and talking to folks about water mediation and water conflicts, and just to say that this really has been a terrific conference and it's been an honor to be part of it. So let's see, I point it right there. So mediation as an alternative to litigation for water disputes. There was a study done at Oregon State University a couple of years ago that looked at treaties and agreements and all sorts of information that they collected across the world, looking at this issue of, are we fighting more about water, or are we actually collaborating more about water? And the good news is wherever they looked, for the most part, they came up with the same result, which is there's more collaboration on resolving water problems internationally now than there is actual, serious conflict. And so that's good news and something that people don't really generally know. But folks all over the world are finding ways to sit down and try to resolve their water issues. And that's really what I'm going to talk about today. And I'm going to talk about a couple of examples here, if I can get, there we go. In the United States, really going to spend my time on the last two, which I had some involvement with, but I'm going to start with Florida versus Georgia. You probably heard that Florida had sued Georgia and that case had gone to the Supreme Court, and they'd actually had a hearing on January 8th, the same day that they heard Texas versus New Mexico. Now, as I say down there, that dispute's over the use of the Apalachicola-Chattahoochee-Flint River Basin, and that more than $102 million have been spent since that case was filed in 2013. Well, let me amend what I said about that price tag. That is what Florida had spent through 2016. The hearing for the Supreme Court was last month. And so the real cost of that litigation is probably much closer to $200 million. Really kind of hard to get your head around that, at least it is for me. The next case is Aransas Project versus Shaw. This is the whooping crane litigation. And that case, about $15 million was spent. between 2010 and 2015. And then finally down there, Sierra Club versus Babbitt, the Edwards Aquifer litigation. I don't know why, for some reason, it's in white down at the bottom there, but it's about $8 million spent back in the 1990s, at least $8 million that we know of. And so for that case, the Edwards Aquifer case, it was an Endangered Species Act case. This is a fountain darter, one of the 8 endangered species at Comal and San Marcos Springs. But there was a lot more going on with that case than just endangered species. So this is the Edwards Aquifer, and what you can take away from this is that essentially out west of San Antonio, that's the area where irrigation is taking place, and then San Antonio is a big municipal user of water, and then the springs on the east part of the aquifer at Comal and San Marcos Springs are where the endangered species are. So now going back to the 1990s and thinking about the legal journey that a drop of water went on, it would fall onto the drainage area in green, and as soon as it got into a water course, what was it? It was state-owned water. And so you could have a permit to use that water if it was granted by TCQ. Now, when it flowed down across the Edwards recharge zone, which is in the kind of the royal blue color there, then it entered into the aquifer and became privately owned water. Now, if it made it out of the aquifer past the pumping into Comal or San Marcos Springs, as soon as that drop of water saw the light of day, it was magically transformed back again into state-owned surface water. So while the Endangered Species Act was really the vehicle for this litigation, the real issue here was that downstream of the springs, surface water permits had been issued going back to the early 1900s that were based in part on flow out of these two springs. And over time, as more and more water was used out of the Edwards Aquifer, the springs were faced with a situation where they were going to dry up. And so Sierra Club being concerned about endangered species, Guadalupe Blanco River Authority being concerned about their senior water rights, got together, and it resulted in the litigation. Now, for the River Authority, see if I can go back one. For the River Authority, in a dry year, and this is just a typical drought, 80% of the water they had in the river basin was coming out of those two springs during dry periods. So you can see from their point of view the serious nature of having some regulation of the aquifer to protect their water uses. So this is the judge I work for, Judge Bunton, and in that case, his ruling said, and this ruling came out right at the beginning of the 1993 legislative session. He said, the next session of the Texas legislature offers the last chance for adoption of an adequate state plan before the blunt axes of federal intervention have to be dropped. Now, if you want to be hit by an axe, it's not a blunt axe. You want a sharp axe. And so what the judge essentially was saying there was, Texas legislature, you need to manage this aquifer, or the law tells me I'm going to have to do it. And so the legislature listened to Judge Bunton, and at the end of the session, here is Governor Ann Richards and Secretary of Interior Bruce Babbitt and a whole bunch of legislators, and they're celebrating the creation of the Edwards Aquifer Authority. And so they're thinking, hey, all this fighting over water from the Edwards Aquifer and the Guadalupe River that was happening between San Antonio and Guadalupe River interests, and which began really in the 1930s, maybe that's come to an end. Well, it didn't quite. The Edwards Aquifer Authority was created, and it put in a permitting program and gave people out permitted amounts of water to use, and put in a drought management plan with drought management rules, and they did that very well. The last part of it was very hard to do, and essentially that was to meet the needs of the endangered species. The legislature had said, you've got to have continuous minimum flows of water coming out of those springs by 2012. Now, why would the legislature say 2012? And they created this entity in 1993 because the thinking there was it's going to take about 18 or 19 years to build a significant reservoir for San Antonio to supplement their use of the Edwards Aquifer. And so there was a period in there of time that they were given to do that. But unfortunately, that didn't happen. You may remember Applewhite Reservoir. That was a reservoir San Antonio water system was going to build, and it was voted down twice by a local referendum. And so there was not a solution to that part of this problem. And so the legislature stepped back in 2007. They said, here's what we're going to do. We're going to take stakeholders from both sides of this thing, and we're going to give you 5 years to come up with a plan to manage this resource. And if you don't, here's some draconian things that are going to be put in place automatically if you can't come up with a plan that meets everybody's needs. And so go ahead and go do it. So the stakeholders, who are a group of about 60 to 100, depending on the meeting, who met every month from the middle of 2007 until December 2011, and had work group and subcommittee meetings in between those monthly meetings, came up with a plan. And it was a lot of work, but it's done very well. And so let me just briefly try to tell you what's in that plan. First of all, they found much less expensive ways to do things than people have been thinking about before. One of the major things that they do is they have a program where irrigators can sign up and get a payment every year for their water, and then in a really bad drought year, they get a notice, before they do their planting, they get in October, that next year we're going to need your water, and they get a balloon payment. And so about 40,000 acre feet of water are in that program that irrigators get paid for. In addition to that, some of the other two major things that they do, San Antonio Water System has an aquifer storage and recovery facility. The stakeholders purchase water and store it in SAW's ASR facility and take it out during a drought to supplement pumping from the Edwards Aquifer and to keep the springs going. And then also there's a punitive measure in here. If all these other things don't work, there's a 44% cutback in permitted water uses to get us through another drought like the drought of record in the 50s. And its oversight is done by a group of 6 stakeholders in a committee that meets every other month, and the National Academy of Sciences, which checks what they're doing and advises the stakeholder group. So how much does that cost? It's $18 million a year. And you look at that and you say, that is an unbelievable amount of money. The alternative for this was $2.2 billion, the pipeline from the Colorado River to San Antonio. And when that project was canceled, the price was going up on that. And so this solution, even though it was very expensive, was a fraction of the cost. And most of the measures in here are water conservation measures and water marketing measures, essentially. And so here's the day where we posed for our photo, having reached an agreement. The thing to note about this is most of these people have been suing each other for years and have been, when they weren't in court, they were in the legislature fighting each other. A number of my friends from Austin are here today. That's when they used to see me, was down at the legislature, essentially. And when I was working for the Guadalupe Blanco River Authority, and the San Antonio Water System and GBRA were going at it in the legislature over what to do about the Edwards. None of that happens anymore. And so it's been a tremendous benefit. So, next issue, whooping cranes. This is another dispute that I was involved with. There we go. So Whooping cranes originally occupied a whole bunch of areas in the United States, down into Mexico during the winter months. And the remnant population today breeds, if you can look up at the top left corner of that circle, that's Northwest Territories in Canada, Wood Buffalo National Park. And so they breed up there, and they fly all the way down to the Aransas National Wildlife Refuge on the Texas coast. And so the population, which was down to about 24 in 1940, 1942, is now up to about 431 in this one natural flock. This is the one existing wild flock. And so that's good news, but 431 birds is not a lot. There are other populations. These are experimental populations, but generally they have not met with a whole lot of success. And so, talking about the Guadalupe River again, the Guadalupe River flows into San Antonio Bay, and around San Antonio Bay is where the cranes winter, and the flow of fresh water from the Guadalupe River mixes with the bay and provides the right salinity levels for many of the things that the whooping cranes eat during the winter. So in red, you see kind of the key habitats for the cranes there at Aransas National Wildlife Refuge and across at Matagorda National Wildlife Refuge. And the blue areas are kind of, that's habitat that they can use, but it's not as good. So in 2008 and 9, there were whooping crane deaths during the winter. And a few years after that, the Aransas Project sued TCEQ saying, you had historically given out too many permits to withdraw water from the Guadalupe River, and so that's what somehow led to the death of the cranes. So too much fresh water was withdrawn from the river, and then you had crane deaths during that winter. Well, the Aransas Project, they won at the district court and lost at the circuit court. Then in 2016, they decided, hey, look, let's just call GBRA and see if we can sit down and hash something out, come up with some kind of agreement to do something. And lo and behold, we sat down, and really within just a few weeks, about as long as it takes me to go to the next slide, we hashed out an agreement. And that agreement provided for some additional water for freshwater inflows for the Guadalupe Estuary, San Antonio Bay, a long-term habitat conservation strategy. That turns out to be the actual key issue for the cranes, is the amount of habitat along the Texas coast for that population to continue to expand into. And then other things like what's a long-term water supply strategy for that river basin that will not impact whooping cranes. The first priority is habitat, and the second priority is water. And so there we are at San Marcos Springs, celebrating the agreement, which GBRA and TAP had been in. That was the third lawsuit that they'd been in over 10 years, and everybody was able to resolve their differences and move forward. If you want to read about that issue, it's in the Water Report in an article I published last summer. So, resolving water conflicts through litigation. Once we assume that we're going to use the adversarial model or the litigation model, what often happens is our water planning kind of starts to transform into building a case under the legal rules of evidence. And, the means, litigation, can sometimes become the end. And you get polarization, and then the system starts to generate more conflict than it resolves. So there are options to avoid that, and mediation is one. And so I'm going to just go through briefly what are the advantages of mediation. Well, first of all, we're talking about something that's generally voluntary in nature. You can sit down with your your opponent and try to hash out your differences or not. You don't have to, but it's an option. Non-judicial decisions. Judges and other third-party decision makers don't know the issue as well as you do. And so if you want to retain more control over the outcome, it's better if you're able to hash out an agreement than having to have a third party do it. Greater flexibility in terms of the settlement. You know, often when a judge rules, it's over narrow points of law. And so that may or may not get to the issues that you're really litigating and trying to resolve. And so again, that's an advantage for mediation. Savings in time, and then cost savings down below there. That's really the driving motivation for most folks who get into mediation over these disputes. It's substantially less expensive. I mean, you saw the Georgia-Florida example, which is hopefully an outlier, but it's also much faster. And so, you know, everybody's trying to save money and to do things faster. This is a really critical point which you don't hear about all that often. A lot of times when entities are water districts, cities and water districts are in litigation with each other, look, they've got to work with each other in the future. And often I see this, you know, two entities are litigating with each other, they have a bitter court dispute, then it's on to the next water project, and guess what? The next water project would be, what? Faster and cheaper to do with working with some of the regional entities, but hey, those guys just sued us. And you remember what they said about us in the newspaper? I can't tell you how many times I've heard that over and over again, but that's the truth. It's a small world after all, right? And you know, you got to continue to work with those other folks that you may be fighting with right now. The short term, you're trying to resolve whatever the specific issue is, but the long term is, you know, San Antonio can't move away from the Guadalupe River, and the Guadalupe River can't move away from the Edwards Aquifer. They're stuck together. And so, just briefly here, you want to get a dispute resolved and have it be a long-term, durable dispute. You've got to think about the three interests that have to be met. And so those interests are substantive interests, water. I have to have a certain amount of water. Procedural interests, okay, how are we going to implement this, and how are we going to resolve other disputes that might arise under this process? You get a process in place that everybody understands and knows the rules about. And then psychological or relationship interests, you rebuild the relationship between the entities. And, you know, I've seen that done over and over again, where people who just could not stand each other, now, you know, we call each other up and talk to each other, and we visit with each other about projects that we're thinking about, and sometimes that helps us head off issues that we might get into otherwise with each other. So when you have all three of those interests satisfied, that's really when you get a long-term agreement that is going to mean something. So just a brief mention of what's coming up. Freshwater mussels. So this is the good news for you. If you are in the Canadian or the Red River basins, right now there's no proposal for listing of any of these mussels. The first one, the Texas horn shell, is being listed in the Rio Grande, and the second tier are in central Texas in the Brazos, Colorado, Guadalupe, and San Antonio River basins. And so the good news about that is that it's being managed in a collaborative process by the Texas Comptroller's Office, which has a endangered species committee. Let me flip forward one more. That works through issues like this and is a way to do so without spending all the money that's been spent previously in all these lawsuits. And so, you know, we've been meeting with other folks in Central Texas and coming up with a plan for those muscles, which will probably be kind of a model for how other sections of the state do it. And I can already tell you that the collaboration I've seen is showing me that the solutions are going to be much less expensive and intrusive than they would have been otherwise. And so that's good news. So in summary, dispute resolution through mediation offers a better alternative to the adversarial legal model in many instances. Sometimes you do have to go to court, but not always. Relying on litigation excludes building common ground among water interests. And obviously, it's not always effective when you go to litigation. So just think about that in the future, that the relationship between the entities is an important long-term consideration. And mediation can help you